The Senate will come to order. The chaplain, Dr. Barry Black, will lead the Senate in prayer.
Let us pray. Eternal God, giver of every good and perfect gift, use our lawmakers today to cause justice to roll down like waters and righteousness like a mighty stream. May our senators strive to do what is right, love mercy, and live humbly for your glory. Guide them to turn their ears to your wisdom as you illuminate their hearts with your truth. May they call on you for direction, depend on your prevailing providence, and defend the truth regardless of the consequences. Grant that their faithfulness to you will be like the light of morning at sunrise, like a morning without clouds, and like the sun gleaming on new grass after rain. We pray in your glorious name. Amen.
Please join me in reciting the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all. The clerk will read a communication to the Senate.
Washington, D.C., April 17, 2024. To the Senate, under the provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable John W. Hickenlooper, a senator from the state of Colorado, to perform the duties of the chair. Signed, Patty Murray, President pro tempore.
Under the previous order, the leadership time is reserved. Morning business is closed. Under the previous order, the Senate will resume consideration of the motion to proceed to H.R. 7888, which the clerk will report.
Motion to proceed to calendar number 365, H.R. 7888, an act to reform the Foreign Intelligence Surveillance Act of 1978.
Mr. President.
The Majority Leader.
Mr. President, this afternoon, senators will come to the floor and be sworn in as jurors in the impeachment trial of Secretary Alejandro Mayorkas. Yesterday, the Senate received the impeachment House managers who read the 2 articles against the Secretary. Today, the trial will commence, and we will be in our seats as jurors for the 3rd time in 4 years. But this time, senators will provide as jurors in the least legitimate, least substantive, and most politicized impeachment trial ever in the history of the United States. The charges brought against Secretary Mayorkas fail to meet the high standard of high crimes and misdemeanors. To validate this gross abuse by the House would be a grave mistake and could set a dangerous precedent for the future. For the sake of the Senate's integrity and to protect impeachment for those rare cases we truly need it, senators should dismiss today's charges. So when we convene in trial today, to accommodate the wishes of our Republican Senate colleagues, I will seek an agreement for a period of debate time that would allow Republicans to offer a vote on trial resolutions, allow for Republicans to offer points of order, and then move to dismiss. Let's not kid ourselves about what's going on today. The impeachment of Alejandro Mayorkas has nothing to do with high crimes and misdemeanors, and everything to do with helping Donald Trump on the campaign trail. Secretary Mayorkas has not been accused of treason or accepting bribes or unlawfully attacking our elections or anything of the sort. He has not been accused of criminal wrongdoing. He did not blackmail a foreign power to dig dirt on a political opponent, nor did he incite a violent mob to wage an insurrection against the peaceful transfer of power. Instead, the hard right wants to exploit the supremely serious matter of impeachment for the sake of cable news hits and content for social media. This is an illegitimate and profane abuse of the U.S. Constitution. The framers were clear. Impeachment should never be used to settle policy disagreements. Legal scholars from across the ideological spectrum have agreed to the same for decades. Even the Wall Street Journal editorial board, the darling of the conservative intelligentsia, argued a few months ago that, quote, a policy dispute doesn't qualify as a high crime and misdemeanor, unquote. If our House Republicans want to have a debate about the border, Democrats are glad to have it. But instead of wasting time on impeachment, we should debate bipartisan legislation to secure our border once and for all. In fact, that is precisely what we tried to do in this chamber just a few months ago. I worked with a handful of Democrats and Republicans to draft the strongest border security bill to come before the Congress in decades, before Donald Trump and the hard right killed it in its tracks. It was everything that what Republicans could have wanted and more. A bill to hire more Border Patrol agents, reform asylum, fight the fentanyl crisis, and create brand new powers for the president to close the border. It was strong, strong stuff. And the National Border Council, the National Border Patrol Council, the Chamber of Commerce, and the ultimate conservative Wall Street Journal editorial board all threw their support behind our bipartisan bill. If both chambers would have voted on it, I am certain it would have passed and be signed by the president. But that's precisely why Donald Trump and the hard right were afraid of it. Instead of providing a solution to the border, Donald Trump and his MAGA radicals want to exploit the border for political gain. And today, with this trial, MAGA radicals want to likewise exploit our Constitution and try to gain an edge on the campaign trail. It is beneath the dignity of the Senate to entertain this nakedly partisan exercise, one that both conservative and liberal legal scholars agree fails to meet the high standard demanded by impeachment. So I will say it again. Impeachment should never, never be used to settle policy disagreements. That would set a disastrous precedent for the Congress and could throw our system of checks and balances into endless cycles of chaos. Now on Senate business. The Senate might be stuck addressing the House's bogus impeachment charges, but that doesn't erase the fact that we have a lot of work to do in the Congress in the upcoming days. Before April 19th, the Senate must come to an agreement on FISA reauthorization. Last night, I filed cloture on the motion to proceed to the House-passed FISA bill, and that vote is set to take place tomorrow. Democrats and Republicans are going to have to reach an agreement if we want to get FISA reauthorization done before the deadline. Otherwise, this very important tool for ensuring our national security is going to lapse, and that would be unacceptable. The House has not made our jobs any easier with this bogus impeachment trial, but that doesn't let us off the hook to work together quickly to get FISA reauthorization done. On another important matter, we are still waiting to see how Speaker Johnson and House Republicans will proceed on the National Security Supplemental Package. One way or another, I fervently hope, that we can finally finish the job in the next couple of days. But that is not certain and will depend a lot on what the House does. The entire world is waiting to see what House Republicans will do about aid to Ukraine, aid to Israel, humanitarian assistance, and aid to the Indo-Pacific. Putin is watching very closely to see if America will step up and show strength or slink away from a friend in need. And anyone who thinks the war in Ukraine is just a regional conflict in Eastern Europe, the Chinese Communist Party would beg to differ. If President Xi sees America waffle in helping Ukraine, he may conclude that we will similarly get cold feet in the Indo-Pacific. Congress must finish the work on the supplemental once and for all. The time for waiting and delay has long been over. I urge House Republicans to continue working in a bipartisan spirit to get this aid passed. The security of America, of our friends abroad, and of Western democracy itself demands that we act. Now, later today, President Biden will call for the tripling of tariffs on steel and aluminum imports from China. This is a strong and decisive response to continued unfair trade practices by China. I've been a loud and fervent advocate of higher tariffs on Chinese steel and aluminum imports for years. When I first became senator, I saw for myself how unfair Chinese practices were carving away at American production and American jobs. The deck has long been stacked against U.S. steel and aluminum workers for years because of the Chinese government. For China, the equation's simple. They overproduce steel and aluminum with the help of subsidies and low-cost labor, then flood markets with these cheap products, and then dominate any competition and reap the profits. American businesses end up falling further and further behind. Critically, the President is also calling for action to prevent companies from routing steel and aluminum imports through Mexico in an attempt to circumvent the tariffs. There is perhaps no industry that has felt the impact of China's unfair trade practices than shipbuilding. The U.S. was once a global leader, but now we produce less than 1% of the world's commercial ships. Over the last 2 decades, China has dramatically increased its dominance of the shipbuilding industry, putting American businesses and workers at risk and jeopardizing our national security. So the President's announcement today is a welcome step to getting American steel and aluminum businesses back on the level playing field with China. I can assure you, Mr. President, there's no shortage of American businesses ready to step up and compete in the global market. In my home state of New York, union steelworkers in places like Western New York and Messina helped forge the steel and aluminum that built America's bridges and buildings, and they stand ready alongside other manufacturing powerhouse communities in Ohio, Pennsylvania, and elsewhere who built America from the ground up. So I commend the President for a strong and decisive call to triple the tariffs on steel and aluminum imports from China, and Democrats will keep working to bring American businesses and workers back on the level with the world. And finally, Mr. President, today we're mourning a colleague and former member of this chamber, Bob Graham, who passed away yesterday at the age of 87. Bob and I only served for a few years, but it didn't take long to realize he was a man of great integrity. He was a devoted public servant who dedicated his entire life to his beloved Florida, from the state legislature to the governor's mansion to the halls of the United States Senate. Our prayers are with his family and his loved ones. Mr. President,
Majority Leader.
I ask unanimous consent that the Senate proceed to the immediate consideration of S-Con Res. 33.
The clerk will record.
S-Con Res. 33, concurrent resolution authorizing the use of the rotunda of the Capitol and so forth.
Without objection, the Senate will proceed.
I ask unanimous consent that the concurrent resolution be agreed to, the motion to reconsider be considered made and laid upon the table with no intervening action or debate.
Without objection.
I note the absence of a quorum.
Clerk will call the roll.
Ms. Baldwin.
President,
Republican leader.
I ask consent further proceedings on the quorum call be dispensed with.
Without objection.
As I discussed earlier this week, critical national security authorities under the Foreign Intelligence Surveillance Act are set to expire in 2 days. Today, I'd like to briefly address the newest red herring being raised in opposition to authorizing Section 702. The reauthorization that passed the House contains scores of important reforms to the FISA process that will enhance accountability at the FBI and protect the rights of American citizens. It also included a necessary fix to the way we authorize the government to lawfully collect communications from foreigners located overseas for a specific intelligence purpose. As part of the standard judicial oversight of the 702 process, the intelligence community has been restricted in what kinds of technology counts as, quote, electronic communications service providers, end quote, under the statute. When Section 702 was written, the internet was in the dark ages compared to how it exists today. Clearly, social media and internet communication usage has changed dramatically since the earliest days of Twitter, and so have the technical mechanisms by which massive packets of data transit the internet. As the internet evolved, the FISA court did not allow DOJ on its own to expand the definition of a provider to meet the new realities of contemporary technology. This created a critical unintended gap in our collection ability against overseas foreign targets. Here's the good news. The House did, on a strong bipartisan basis, what legislatures should do. In fact, a majority of the majority and a majority of the minority voted to change the statute to make sure that our collection ability on foreigners overseas reflects the reality of modern communication. It was a simple fix to update the law to respond to technological change. But to listen to the chicken littles on the left, the sky is falling. The ACLU says this will expand warrantless surveillance and strongly implies that it will do so against Americans as they go about their daily lives. Demand Progress, an activist arm of Arabella Advisors, says everyone is a spy under this provision. Well, excuse me if I don't take my cues from liberal court packers. This could not be further from the truth. The House bill, simple fix, does nothing to change who gets targeted by Section 702. Foreigners overseas, these communications are likely to return important intelligence. The FISA appellate court affirmed this in a decision that predated the legislative fix, saying under Section 702, the government is prohibited from intentionally targeting any person known at the time of acquisition to be located in the United States. Even foreigners located in the United States, even foreigners operating illegally in the United States. The court went on saying, quote, customers using Wi-Fi access provided by a cafe or library, for example, would not be targeted under Section 702, regardless of whether the internet connectivity being provided is considered an electronic communications service. So let me say that again. They would not be targeted under Section 702, nor, contrary to the fears of some of our colleagues, would U.S. persons be at risk of drone strikes as they surf the internet on public internet networks. Nothing has been expanded. Section 702 still rightly only applies to foreigners overseas. All that the House did was fix a dangerous loophole that would have allowed our foreign adversaries to escape the reach of our intelligence services. Trust but verify, right? Well, this bill helps us do precisely that. It includes significant reforms that dramatically enhance transparency into how Section 702 is used by the intelligence community. It includes important reforms to prevent misuse of the authority and require accountability for any such misuse, including new civil and criminal penalties. So, I would urge my colleagues to look at the facts of this latest fear-mongering crusade, to soberly examine the same classified material our House colleagues read that explains this provision in detail, to reject hyperbole and lies and take action to secure the homeland. Now, on a different matter, we do have a plan to address migration at the southern border. We're executing it, and we're starting to see the results. Well, those were the words of Secretary of Homeland Security after the Biden administration had been in office for 8 months. But in the past 3 years, they've taken on an altogether greater significance. The administration's plan to address migration, turns out their plan was exactly what then candidate Biden pledged on the debate stage: to surge migrants to the border. How did they execute it? By slashing the previous administration's common sense border security policies. No more remain in Mexico, no more border wall construction. As Secretary Mayorkas bragged back in 2021, the Biden administration had repealed so many border enforcement tools that, quote, it would take so much time to list them. And how about that last part? We're starting to see the results. Since this administration took office, the surge in illegal arrivals at the southern border has set and broken new all-time records several times over. CBP personnel have worked overtime to contend with a humanitarian and security crisis. And yet for years, the Biden administration's top concern about the border was not calling it a crisis. Again, quote, we do not have a plan to address migration at the southern border. We're executing, and we're starting to see the results. Results? Indeed. Mr. President, in the form of a tragic, painful, and unnecessary crisis. Today, it falls to the Senate to determine whether and to what extent Secretary Mayorkas enabled and inflamed this crisis. Under the Constitution and the rules of impeachment, it is the job of this body to consider the articles of impeachment brought before us and to render judgment. The question right now should be how best to ensure that the charges on the table receive thorough consideration. But instead, the more pressing question is whether our Democratic colleagues intend to let the Senate work its will at all. Tabling articles of impeachment would be unprecedented in the history of the Senate. It's as simple as that. Tabling would mean declining to discharge our duties as jurors. It would mean running both from our fundamental responsibility and from the glaring truth of the record-breaking crisis at our southern border. I, for one, intend to take my role as a juror in this case seriously, and I urge my colleagues to do the same.
Clerk will call the roll.
Ms. Baldwin.
Mr. President.
The Republican whip.
Mr. President, is Senate in quorum call?
We are.
I would ask unanimous consent the quorum call be lifted.
Without objection.
Thank you, Mr. President. Mr. President, 7,633,650. That's the number of migrant encounters at our southern border since President Biden took office. 7,633,650. The situation at our southern border is out of control. We have had three now, successive years of record-breaking illegal immigration under President Biden, and we are on track for a fourth. There have been more than 1.3 million migrant encounters at our southern border since October 1st of last year, which was the start of this fiscal year. 1.3 million just since October 1st of last year. And that number just refers to individuals who were actually apprehended. There have been almost 150,000 known gotaways so far this fiscal year, and those are individuals that the Border Patrol saw but was unable to apprehend. Often we see migrants turning themselves into authorities, so it's especially concerning to know that so many individuals have purposely evaded interdiction. And of course, we don't know how many unknown gotaways there have been. U.S. Border Patrol Chief Jason Owens, in a March interview with CBS News, said the number of known gotaways is keeping him up at night. This is a national security threat, he noted. That's a quote. Border security is a big piece of national security, he goes on to say. And if we don't know who is coming into our country and we don't know what their intent is, that is a threat, and they're exploiting a vulnerability that's on our border right now, end quote. That again, Mr. President, from Jason Owens, U.S. Border Patrol Chief. Well, Mr. President, the situation at our southern border right now is a national security threat. There's no question that the kinds of numbers we're seeing smooth the way for dangerous individuals to enter our country. During fiscal year 2023, 169 individuals on the terrorist watch list were apprehended trying to cross our southern border. More, I might add, than the previous 6 years combined. And that's just the individuals, again, who were actually apprehended. With somewhere around 1.8 million known gotaways since President Biden took office, and an untold number of unknown gotaways, I think we can safely assume that there are plenty of dangerous individuals making their way into our country without being stopped. Mr. President, while there are always various factors that affect the flow of illegal immigration, we are on track for a fourth record-breaking year of illegal immigration under the Biden administration because of the actions that President Biden has taken or failed to take. From the day he took office, when he rescinded the declaration of a national emergency at our southern border, President Biden made it clear that border security was at the bottom of his priority list. And over the 3 years since, he has turned our southern border into a magnet for illegal migration, from repealing effective border security policies of the Trump administration to abusing our asylum and parole systems, which are now providing temporary amnesty to hundreds of thousands of individuals here illegally. Which brings me, Mr. President, to today. In just a few minutes, the Senate will be sworn in to consider the articles of impeachment against Homeland Security Secretary Mayorkas, one of the chief architects of the Biden administration's lax border security regime. And we expect that the Democrat leader will move almost immediately to dismiss the charges. At most, we expect a few hours of process with no examination of the evidence the House has collected and essentially no consideration of the serious charges before us. Mr. President, whether or not senators ultimately decide that Secretary Mayorkas' actions warrant a conviction, They should be given the time to actually examine the charges. In a courtroom, a case is not dismissed without the court taking the time to examine the facts. And the Senate, sitting as a court of impeachment, should be no different. The Senate should be having a full trial and taking the time to examine the evidence that the House has collected. And then, senators should be able to vote guilty or not guilty. Instead, the Senate leader is set to sweep these charges under the rug. It's just more evidence of the fundamental unseriousness Democrats have shown when it comes to the raging national security crisis at our southern border. Mr. President, by the end of the day, the Democrat leader may well have effectively made these charges disappear. But there is nothing that the Democrat leader can do to obscure the failures of Secretary Mayorkas and President Biden. Thanks to their refusal to secure the border, we have experienced 3 now successive years of record-breaking illegal immigration. And unfortunately, there is no end in sight. Mr. President, I yield the floor, and I suggest the absence of quorum.
Clerk will call the roll.
Ms. Baldwin.
Mr. President,
The Senator from Virginia.
Mr. President, are we in a quorum call?
We are.
I ask that the proceedings of the quorum be dispensed with.
Without objection.
Thank you, Mr. President. Mr. President, I rise today as Senator from Virginia and, more importantly, as Chairman of the Intelligence Committee in supporting of the Reforming Intelligence and Securing America Act, H.R. 7888, which passed the House earlier this week with a 273 to 147 broad bipartisan support. Section 702 of the Foreign Intelligence Surveillance Act, FISA, which a lot of this debate focused on, is a critical source of foreign intelligence. It is indispensable to the work that the men and women of our intelligence community and many others do every day to protect our national security. Section 702 authorities have enabled the IC to thwart terrorist attacks, track foreign spies, uncover economic espionage, impede weapons proliferation, protect U.S. troops, expose human and drug trafficking, prevent sanctions evasion, and disrupt foreign cyber attacks. A whole litany of the responsibilities of the IC. Just to demonstrate how important these capabilities are to our national security, 60% of the items that appear in the President's daily intelligence brief actually are sourced to information obtained pursuant to Section 702. In the public domain, there are many examples of the value of Section 702. These include when Section 702 contributed to the successful operation against one of the last remaining 9/11 architects, Zawahiri. Or Section 02, it was Section 02 coverage that identified evidence of an Al-Qaeda courier in Pakistan with imminent plans to detonate explosives on subway tracks in Manhattan, and through that surveillance was able to prevent the attack. 702 section identified the hackers responsible for the 2021 ransomware attack on Colonial Pipeline that crippled fuel supplies across the East Coast and enabled the United States to recover $2.3 million in paid ransom. Secretaries of Defense, directors of national intelligence, and many other cabinet officials from both the current and the former administration have spoken out on the vital importance of ensuring that Section 702 does not lapse. To quote the President's Intelligence Advisory Board, if Congress fails to reauthorize Section 702, history may judge the lapse of 702 authorities as one of the worst intelligence failures of our time. And quite honestly, that's what we're looking at if we don't get this done. Nonetheless, as we indicated, we just find ourselves just hours away from a possible sunset of this critical authority, which sunsets Friday night at midnight. Now, some members have argued that because the FISA court recently approved new certifications, there's no urgency to reauthorize the law. Those claims are both misguided and dangerous. In the event of a statutory lapse, some providers, American companies who are working with us, are likely to stop or reduce cooperation, perhaps with existing targets of collection, but especially with new ones. We know this can happen because it's exactly what happened when a similar lapse occurred following the expiration of Section 702's predecessor statute, the Protect America Act. Now, to be fair, it is also true that Section 702 is in need of some reforms. And myself, Senator Rubio, 16 members, bipartisan, have sponsored the Senate version of this bill, have pressed for additional reforms to protect the civil liberties of Americans while still preserving the core values of the program and protecting American national security. In recent years, a key oversight focus has been on the number of queries of Section 702 information. Section 702 is a database. There are a series of databases. You can sometimes query that database within certain protections. Now, the focus is focused on particularly those queries performed by the FBI and involving U.S. persons. There's no dispute that for too long, the FBI query practices were sloppy. For a time, as recently as 2019, more than 3 in 10 of the FBI queries were non-compliant. That means literally 30% of the time, the FBI was not even following their own procedures. The FBI took much too much time to implement needed reforms. But finally, in 2022 and 2023, it implemented comprehensive reforms that have proven effective and dramatically improved the query compliance rate from 70% to over 90%. It means less than 1% of these queries fall outside of the reform practices that the FBI has put in place. What do these reforms include? Maybe one of the most important ones is that rather than by default, FBI agent queries a series of databases. In the past, they'd have to opt out of querying the 702 database. Now they have to opt in and make the case that they need that for national security purposes. Another reform that's been in place. There was a series of actions in the past called batch queries. A group of people might be arrested and suddenly you're querying a whole batch of them. Those batch queries have been dramatically diminished. At the same time, there are new reforms that requires the FBI leadership to approve sensitive queries of politicians, journalists, and religious leaders. Literally, it has to be the director of the FBI, the deputy director, or the head of the National Security Division. The bill before us, which again, we had pre-conferenced most of this with the House. This is the House bill we're going to be taking up later this week. The bill before us now codifies these reforms, ensuring that a future president, attorney general, or FBI director cannot simply walk them back. When we pass this legislation and it's signed, these reforms will become law of the land. In addition to the reforms I've already talked about, the bill we are debating goes even further. It also includes significant new protections for U.S. person queries, including a complete prohibition on queries solely used to find evidence of a crime, as was unanimously recommended by the President's Intelligence Advisory Board. The bill also increases transparency of FISA court proceedings, going so far, and this was added in the House, as to allow members of Congress and their staffs to attend court hearings. We've heard on this floor and the floor of the House many times, we don't know what's going on in the FISA court hearing. Well, now, if a member of Congress wants to sit in or send their staff, they'll be able to do that. This legislation also enhances reporting requirements from both the Bureau and the intelligence community, and creates an ongoing reform commission to recommend further FISA reforms. Truth is, Section 702 is already the most regulated and closely overseen intelligence authority of any we have in this country, and frankly, in countries around the world. If enacted, the reforms included in this bill would be the most comprehensive set of reforms ever enacted in this statute's history. We've often reformed this every 5 years or had to be reauthorized. This set of reforms are much more extensive than actions in the past. Now, I would like to speak briefly on two issues that have been the subject of considerable debate. First, some have suggested that we should impose a warrant requirement on U.S. person queries. Let me again be clear. A warrant requirement for U.S. person queries would do grave damage to national security. The FBI and other agencies have relied on U.S. person queries of Section 702, as I enumerated earlier, to prevent terrorist attacks, investigate cyber attacks, prevent assassination plots, and to disrupt narcotics trafficking. Many of these successes would not have been possible if the government was required to obtain a warrant for U.S. person queries, and significant intelligence would be lost. Because, and people say, well, why is that so hard to put in place? Well, let's think about this for a moment. A warrant requirement requires a plausible cause, a probable cause, that the subject of an inquiry is an agent of a foreign power. The truth is, and I remember talking with the presiding officer about this, the majority of times that an American person is queried is not because we suspect them to be an agent of a foreign power, but because they have been a victim, oftentimes, of a cyber attack. Even the most fervent advocate of a warrants have not been able to explain, if you are trying to decide whether person X has been a victim of a cyber attack, there's no way you could get a probable cause showing that that person is an agent of foreign power. That agent is a victim of a foreign power. And the warrant requirement could not meet the notification requirements put in place. And the idea, well, we could simply contact the person, well, that does not pass the smell test. Sometimes this gets complicated, and it spent me a lot of time trying to get this. So let me give you a couple theoretical ways that this warrant requirement, I believe, falls short. Let's say that the intelligence community is aware that Iran is planning a cyber attack against a U.S. victim, maybe even a victim that would sit in this chamber. In that case, the intelligence community may want to query whether it has intelligence collected against Iran for when Iran or their agents is talking about that American, so that we could actually get the full exposure to make sure that we could both do victim notification and also preclude future attacks. These queries would serve to protect the victim, not investigate him. But it would never be possible to establish, as any warrant application would require, probable cause that the victim is an agent of a foreign power, because they're not. They're a victim. Let me give you another example. Let's assume the United States apprehends a known foreign terrorist overseas. On that person, and I'll point this out for the presiding officer, there's a phone number that's a 303 area code. We don't know whether that phone number is a real number, whether it's the number of an American, whether it's a number of a foreigner, because as the presiding officer knows, somebody might have been a foreigner, gone to Colorado, gone to Denver, bought a phone, carries that phone with them forever. The idea that you could get a warrant of probable cause on the basis of that phone number alone, again, does not pass the smell test. It cannot happen. The truth is as well, some have said, well, we'll give you an exemption for exigent circumstances. The process will not work, or will work in such a slow fashion that the use of this critical tool, 60% of the intel the president reads every day comes from 702 intelligence. The truth is, it would take weeks or months to obtain an order from the FISA court. During the time which the bad guys, go back to the example, we've arrested the terrorist, there's a 303 area code. You're going to wait weeks before you can even query that phone number to see if it's a real number, an American, a foreign person. And then there are some say, well, we'll let you make the query, but we won't let you look at the results. Again, either one of those circumstances basically neuters the whole ability of 702 to work. Second issue, the House passed bill includes an important amendment to the definition of electronic communications service providers, ECSPs, that address collection gaps caused by developments in the internet and telecommunications technology since 702 was first written in 2008. And let me say, as somebody who spent a career in telecom, the world has dramatically changed in the telecom domain from 2008. This amendment, in terms of the definition, is again focused on this current intelligence gap. It still requires that the targeting that goes on in 702 focuses on overseas non-U.S. persons. And contrary to what some members have literally said on the floor of the Senate, this technical amendment that was added in the House specifically excludes coffee shops, bars, restaurants, residences, hotels, libraries, recreational facilities, and a whole litany of similar establishments. It would not, as some critics have maintained, allow the United States government to compel, for example, a janitor working in an office building in Northern Virginia to somehow spy for the intelligence community. Nor would it allow, as some have absurdly claimed, states to use 702 to target women seeking abortions. First of all, state and local authorities don't even have access to raw 702 data. Secondly, the law is and remains crystal clear on this point. 702 cannot be used to target U.S. persons domestically. Period. Full stop. No exceptions. The amendment, the ECSP amendment, was required because, I pointed out earlier, the world of telecom has changed dramatically since the law was first put in place 16 years ago. Keep in mind, back in 2008, when Section 702 was first passed, we had payphones on most corners. And the cloud was actually something that might cause rain rather than be a place where communications data is often stored. So in short, what happens here is that the government served a 702 directive, and this is why this came about. And that American company said, we think your old definition of a service provider doesn't apply to us. And you know what? In litigation, that claim won. And the FISA court specifically said, we need to make sure that we update the definition. The House added that updated definition. Now, I don't believe we should roll that back. This is not, as some have claimed, some broad expansion of 702 powers or jurisdictions. Again, I could get into the complexities of how there are some data centers, it's been reported in the press, that certain times activities that take place at a data center don't fall into the old definition of 2008. Do we really want that data that passes through the data center to be allowed to be lawfully collected? I think we do. Now, let me be first to say that the House bill is not perfect. I think we should have gone for a 5-year reauthorization. The House passed was a 2-year reauthorization. I accept that. I think the reforms that were put in place will further protect. I go back to the earlier comments I made. We've gone from a 30% noncompliance of the FBI to less than 1%. In terms of the warrant requirement, you're never going to get a probable cause warrant if the individual that is being queried is actually the victim of a crime. And we're sure as heck not going to be able to get a warrant requirement met if you capture a terrorist, and I'm going to go from the 303 area code to, I think, Las Vegas at 712, Madam President. If you've got to show, based upon that number alone, you've got probable cause. You don't know who or what that number is until you do the query. And as I mentioned this last couple of moments, this new definition, this technical definition that the House adopted, again, with an overwhelming bipartisan majority, is not an expansion that simply brings up the terminology around telecom providers up to 2024, which was different than 2008. The notion that we would allow this incredibly, in a sense, the crown jewel of our intelligence collection abilities to go dark as we simultaneously try to debate aid for Ukraine and Israel and humanitarian relief to the Palestinians in Gaza, the idea that we would suddenly go dark at this moment in time would be the height of irresponsibility. So I know we've got to get through this afternoon's proceedings, but I would strongly urge members to join me in voting to pass H.R. 7888 without amendment to make sure that we don't have a lapse. And I know we've made documents and individuals available in the SCIF, but if members have got questions, if members have got concerns, if members hear others come to this floor and make other charges. Please talk to me, talk to Senator Rubio, talk to anybody in law enforcement or the intelligence community. That so many of the claims being made here just are not accurate in terms of what this bill does. I think this is a strong reform bill. I think it needs to get passed, and we need to not let this critical authority lapse. Thank you, Madam President, and I that notice the absence of a quorum.
Clerk will call the roll.
Ms. Baldwin.
Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal,
Markey's here.
Mr. Booker, Mr. Bozeman, Mr. Braun, Mrs. Brett, Mr. Brown, Mr. Budd, Ms. Butler, Ms. Cantwell, Mrs. Capito, Mr. Carden, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz,
Yes.
Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mr. Fetterman, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Mr. Young.
A quorum is present pursuant to Rule 3 of the Rules of Procedure and Practice in the Senate. When sitting on impeachment trials, the hour of 1:00 p.m. having arrived and a quorum having been established, the Senate will proceed to consideration of the articles of impeachment against Alejandro N. Mayorkas, Secretary of Homeland Security.
Madam President.
Majority Leader is recognized.
At this time, pursuant to Rule 3 of the Senate Rules on Impeachment in the United States Constitution, the President pro tem emeritus, the senator from Iowa, will now administer the oath to the President pro tem, Patty Murray.
Do you solemnly swear that in all things appertaining to the trial of impeachment of Alejandro N. Mayorkas, Secretary of Homeland Security, now pending, you will do impartial justice according to the Constitution and laws, so help you God?
I do. At this time, I will administer the oath to all senators in the chamber in conformance with the Article 1, Section 3, Clause 6 of the Constitution and the Senate's impeachment rules. Will all senators now stand and raise their right hands? Do you solemnly swear that in all things appertaining to the trial of the impeachment of Alejandro N. Mayorkas, Secretary of Homeland Security, now pending, you will do impartial justice according to the Constitution and laws, so help you God? The clerk will now call the names in groups of 4. Senators will present themselves at the desk to sign the oath book.
Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn. Mr. Blumenthal, Mr. Booker, Mr. Bozeman, Mr. Braun. Mrs. Britt, Mr. Brown, Mr. Budd, Ms. Butler. Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper. Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons. Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer. Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth. Mr. Durbin, Ms. Ernst, Mr. Fetterman, Mrs. Fisher. Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty. Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran. Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray. Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters. Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney. Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders. Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida. Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith. Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune. Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance. Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch. Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
Majority leaders recognized.
Any senator who was not in the Senate chamber at the time the oath was administered to the other senators will make the fact known to the chair so that the oath may be administered as soon as possible to the senator.
The Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent under pain of imprisonment while the Senate of the United States is convened as a court of impeachment to consider the articles of impeachment against Alejandro N. Mayorkas, Secretary of Homeland Security.
Madam President,
Majority leaders recognized.
in a moment, I will ask unanimous consent to allow for debate time, to allow for Republicans to offer and have votes on trial resolutions, and allow for Republicans to offer and have votes on points of order. So, I ask unanimous consent that Senator Lee be recognized to offer a resolution that is the text of S-Res 624, the full Senate trial, that Senator Cruz be recognized to offer a resolution that is the text of S-Res 622, the trial committee, that there then be up to 60 minutes of debate on the resolutions, concurrently and equally divided between the two leaders or their designees, and following the use or yielding back of that time, the Senate vote on or in relation to the resolutions in the order listed, with no amendments to the resolutions in order. Further, that following the disposition of the trial resolutions, if they are not agreed to, Senator Schumer or his designee be recognized to make a motion to dismiss the first article of impeachment, that the motion be subject to only 7 points of order, that there be up to 60 minutes for debate, concurrently and equally divided on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Further, that if Senator Schumer or his designee makes a motion to dismiss the second article of impeachment, that the motion be subject to only one point of order, that there be up to 60 minutes for debate, concurrently and equally divided, on the motion to dismiss and the points of order, and that following the use or yielding back of that time, the Senate vote in relation to the points of order in the order raised and the motion to dismiss. Following that further disposition of Article 2, the Senate vote on the motion to adjourn the Court of Impeachment sine die. Finally, that there be up to 4 minutes for debate equally divided between the two leaders or their designees prior to each roll call vote, all without intervening action or debate.
Is there an objection?
Madam President,
Senator from Missouri.
reserving my right to object. To dismiss or table articles of impeachment against Secretary Mayorkas without a trial here today or in committee is an unprecedented move by Senator Schumer. Never before in the history of our republic has the Senate dismissed or tabled articles of impeachment when the impeached individual was alive and had not resigned. As Senator Schumer said in 2020, quote, "A fair trial has witnesses. A fair trial has relevant documents as part of the record. A fair trial seeks the truth. Nothing more, nothing less." I will not assist Senator Schumer in setting our Constitution ablaze and bulldozing 200 years of precedent. Therefore, I object.
Madam President.
Objection is heard.
Madam President, I raise a point of order that Impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution, and is therefore unconstitutional.
Under the precedents and practices of the Senate, the chair has no power or authority to pass on such a point of order. The chair, therefore, under the precedents of the Senate, submits the question to the Senate. Is the point of order well taken? The Republican leader is recognized. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Brett. Mr. Brown. Mr. Budd. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Mr. Rono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Berkeley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mrs. Shaheen, Ms. Sinema,
I have nothing to do with
Ms. Smith,
that.
Ms. Stallion,
It was the memo that was saying they wanted to.
Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Mr. Young.
A quorum is present. The Senate is considering the point of order presented by the Majority Leader.
Present.
Senator from Texas.
Madam President, I rise to make a motion. The Majority Leader has argued that Secretary Mayorkas' defiance of federal immigration law and active aiding and abetting of the worst criminal invasion in our nation's history does not constitute a high crime or misdemeanor. He has presented no argument on that question. He has presented no briefing on that question, and the position is directly contrary to the Constitution, to the original understanding of the Constitution at the time it was ratified, and to the explicit position of the Biden Department of Justice as argued before the Supreme Court of the United States. The Majority Leader's position is asking members of this Senate to vote on political expediency to avoid listening to arguments. The only rational way to resolve this question is actually to debate it, to consider the Constitution and consider the law.
The Senator will recognize that the Senate is in a non-debatable position. The Senator has a right to offer his point of order, or his motion, but we are in a non-debatable position.
And my motion is to change that so that we can actually debate the law if senators care what the Constitution and law says. I therefore move that the Senate proceed to closed session to allow for deliberation on the question as required by Impeachment Rule 24.
Madam President.
Majority Leader.
In our previous consent request, we gave your side a chance for debate in public, where it should be, and your side objected. We are moving forward.
The question is on the motion.
Ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Mr. Rono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
The nays are 51. The yeas are 51, 49. The nays are 51. The motion is not agreed to. The pending order is the motion made by the Majority Leader on the point of order.
Madam President.
Senator from Louisiana.
Madam President, I have a motion. I think my motion takes precedent. Having heard
Senator Schumer's serious allegations, which in my judgment are specious, about the constitutionality of these impeachment proceedings, we find ourselves in the awkward position, because we're in impeachment proceedings, of being unable to discuss in public the merits of Senator Schumer's claim, and at the same time, my Democratic friends have refused to go into closed session so we can discuss it. So for that reason, Madam President, I move we adjourn this court of impeachment immediately until 12 o'clock noon on Tuesday, April 30th, and I ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to.
Madam President,
The Republican leader is recognized.
the Senate just swore an oath to do impartial justice according to the Constitution and the laws of our country. We swore to discharge a duty that is quite different from our normal work. As a court of impeachment, we're called not to speak, not to debate, but to listen, both to the case against the accused and to his defense. At this point, in any trial in the country, the prosecution presents the evidence of the case, counsel for the defense does the same, and the jury remains silent as it listens. This is what our rules require of us as well. But the Senate has not had the opportunity to perform this duty. The Senate will not hear the House managers present the details of their case against Secretary Mayorkas, that he willingly neglected the duties of his office and that he lied to Congress about the extent of that failure. Likewise, we will not hear the Secretary's representatives present the vigorous defense to which he's entitled. Our colleagues know that we are obligated to take these proceedings seriously. This is what our oath prescribes. It's what the history and precedent require. And I would urge each of our colleagues to consider that this is what the framers actually envisioned. The power of impeachment is one of the most delicate balances our constitutional system strikes with a portion of the American people's sovereign electoral authority. It purchases a safeguard against malpractice, and it gives the Senate the power and the duty to decide. This process must not be abused. It must not be short-circuited. History will not judge this moment well. Therefore, I move to table the point of order and ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Arono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
The yeas are 49, the nays are 51. The motion to table is not agreed to. The motion before the Senate is the point of order. The question is on whether the point of order is well taken. Is there a sufficient second? There is. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Did she say no? Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, okay. Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 51, the nays are 48. One senator responded present. The point of order is well taken, and the article falls.
Madam President,
Majority Leader is recognized.
I raise a point of order that Impeachment Article 2 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution and is therefore unconstitutional.
Madam President.
Under the precedents and practices of the Senate, the chair has no power or authority to pass on such a point of order. The chair, therefore, under the precedents of the Senate, submits the question to the Senate. Is the point of order well taken? Senator from Utah is recognized.
Madam President, as wrong as the Majority Leader was moments ago in making this particular point of order as to Article 1 of the impeachment articles. Article 1, remember, refers to the willful defiance by Secretary Mayorkas of the law. As wrong as he was in making that as to Article 1, and he was very wrong for the reasons articulated moments ago by the senator from Texas, he is even more wrong, far more so, with respect to Article 2, because Article 2 accuses him of knowingly making false statements. This is a violation of 18 U.S.C. Section 1001, a felony offense. If this is not a high crime and misdemeanor, what is? If this is not impeachable, what is? What precedent will we be setting? We need to address this, and to discuss it, we need to discuss it in closed session. For that reason, Madam President, I move that the Senate proceed to closed session to allow for deliberation on this very consequential point of order that he's just made. That violates hundreds of years of Anglo-American legal precedent and understanding on the question required by impeachment Rule 24.
Question is,
Nays.
the question is on the motion. Is there sufficient second? There is. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Mr. Rono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
On this vote, the nays are 49, the yeas are 49, the nays are 51. The motion is not agreed to. The pending business is the point of order raised by the Majority Leader.
Madam President.
Senator from Florida.
Madam President, as jurors, we have not had the time to review whether this point of order is contrary to the Constitution. Therefore, I move to adjourn the Court of Impeachment until 12 p.m. noon on Tuesday, April 30th, and ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to.
Madam President, a parliamentary inquiry.
Senator will state his parliamentary inquiry.
I appreciate that my friend from New York is eager to get this done with. But are we about to set a precedent that the allegation of a felony is not a high crime and misdemeanor?
That is not an appropriate parliamentary inquiry.
Madam President, I understand there are other ways for the majority to move this off the floor of the Senate, but I would urge my
Does the
colleagues
senator have a motion
to
that he wishes
understand
to make?
what we're doing.
The question is on the point of order raised by the majority leader.
Madam President.
The senator from Louisiana.
Thank you, Madam President. I have a motion, and it takes precedence. As I
State your motion.
appreciate the majority leader's allegation, lying to the United States Congress is not a high crime and misdemeanor. You don't have to be Mensa material to know that it's
The
not
senator
only
will state
a
his
high
motion.
crime and misdemeanor, it is a felony.
Would the senator please state his motion?
I will. Since we're not allowed to talk among ourselves about the absurdity of this, and my Democratic colleagues will not allow us to go into closed session to talk about the absurdity of this,
The Senate is
I
not
move
in a
that we
non-debate
adjourn until 12 o'clock noon on May the 1st, 2004, and I ask for the yeas and nays.
Is there a sufficient second? Would the senator modify his motion? I would ask the senator to modify his motion.
Madam President, 2004 would probably be preferable. But I'll accept a friendly amendment. We make it 2024.
The question is on the motion. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett.
Yes.
Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gilliram. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Arono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to. The pending motion is the point of order preferred by the Senate Majority Leader.
Madam President.
Senator from Kansas is recognized.
Madam President, I have a motion and it takes precedent. Before this body disrespects the Constitution any further, before we endanger our republic anymore, before we harm the reputation of this body anymore, I move to adjourn until 7 a.m. on November 6th, 2024, so the American people can at least have a vote on this impeachment trial.
Question is on the motion. Is there a sufficient second? Is there a sufficient second? There is a sufficient second. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed. The pending motion is the point of order raised by the Majority Leader.
Madam President.
Senator from Alaska.
Madam President, we seem to be in unprecedented territory here, so I have a parliamentary inquiry.
State your inquiry, please.
Madam President, has there been a successfully invoked point of order to dispose of an article of impeachment prior to opening arguments by the House managers?
The chair is not aware of any such occurrence.
Thank you, Madam President.
The pending,
Unprecedented territory, as I mentioned.
Pending business is the point of order raised by the Majority Leader. The yeas and nays.
Madam President. Point of parliamentary inquiry.
Madam President.
The senator from Louisiana is seeking recognition. Will you state why you've asked for recognition, please?
I'm sorry, I couldn't hear you, Madam President.
Senator from Louisiana is recognized.
Thank you, Madam President. I have a motion, and it takes precedent.
State your motion, please.
Before we establish a precedent that lying to the United States Congress is not a felony,
the senator from Louisiana will state his motion.
and before we add a new chapter to the movie Pulp Fiction,
Please, would the
I move
senator,
that we go into executive session to at least allow us to talk about the breathtaking precedent we're about to establish here. And I ask for the yeas and nays.
the question is on the motion to proceed to executive session. The yeas and nays have been requested. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin, Mr. Barrasso,
From 1900?
Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Booker, Mr. Bozeman, Mr. Braun, Mrs. Britt, Mr. Brown, Mr. Budd, Ms. Butler, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy,
How much more of this do we do?
Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Ms. Ernst, Mr. Fetterman, Mrs. Fisher, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mr. Haggerty, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Mr. Hickenlooper, Ms. Arono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Johnson, Mr. Kane, Mr. Kelly, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Chester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to. The pending amendment is the point of order. Pending motion is the point of order raised by the Majority Leader.
Madam President,
The Senator recognizes the Republican whip.
Madam President, I think it goes without saying that the Mayorkas Biden policies have led to the worst border crisis in American history. 7.6 million people apprehended, 1.8 million gotaways. Who knows how many unknown gotaways?
The Senator is reminded that we are in a non-debatable position in the Senate.
The one thing we know is that 357 people were on the terrorist watch list apprehended coming into this country. We have a responsibility to hear these articles of impeachment.
The Senate will be in order.
And therefore, I move to table the Schumer point of order. And I ask for the ayes and nays.
Is there a sufficient second? There is a sufficient second. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Lee. Mr. Lujan. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, the yeas are 49, the nays are 51. The motion is not agreed to. The pending
President,
business is the
parliamentary
point of
inquiry.
order offered by the Senate Majority Leader.
Madam President, parliamentary inquiry.
Senator will state his inquiry.
Madam President, I inquire whether the actions we take today are creating a precedent on impeachments that would apply to all future impeachment actions in the Senate, including an impeachment of the President of the United States.
Impeachment precedents would apply in future impeachment hearings. The question is on the point of order. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capiccio. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley.
Oh, I know.
Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Arono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford, Mr. Lee, Mr. Lujan, Ms. Lummis, Mr. Manchin, Mr. Markey, Mr. Marshall, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Mr. Mullen, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Ossoff, Mr. Padilla, Mr. Paul, Mr. Peters, Mr. Reed, Mr. Ricketts, Mr. Risch, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schmidt, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Tuberville, Mr. Van Hollen, Mr. Vance, Mr. Warner, Mr. Warnock, Ms. Warren, Mr. Welch, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
On this vote, Senate will be in order. On this vote, the yeas are 51, the nays are 49. The point of order is well taken. Article 2 falls.
Madam President,
Majority Leader's recognized.
I move to adjourn the impeachment trial of Alejandro N. Mayorkas, sine die, and I ask for the yeas and nays.
Is there a sufficient second? There is a sufficient second. Clerk will call the roll.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Did he say aye? Mrs. Blackburn. Mr. Blumenthal. Mr. Booker. Mr. Bozeman. Mr. Braun. Mrs. Britt. Mr. Brown. Mr. Budd. Ms. Butler. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Ms. Ernst. Mr. Fetterman. Mrs. Fisher. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mr. Haggerty. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Mr. Hickenlooper. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Johnson. Mr. Kane. Mr. Kelly. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Lee. Mr. Lujan. Mr. Lummis. Ms. Lummis. Mr. Manchin. Mr. Markey. Mr. Marshall. Mr. McConnell. Mr. Menendez. Mr. Merkley. Mr. Moran. Mr. Mullen. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Ossoff. Mr. Padilla. Mr. Paul. Mr. Peters. Mr. Reed. Mr. Ricketts. Mr. Risch. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Schatz. Mr. Schmidt. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Tuberville. Mr. Van Hollen. Mr. Vance. Mr. Warner. Mr. Warnock. Ms. Warren. Mr. Welch. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
On this vote, the yeas are 51, the nays are 49. The motion is to agree to. The Senate, sitting as the court of impeachment, stands adjourned sine die. Majority Leader is recognized.
For the information of members, there are no further votes today. Now, I remind all members that we have very serious business ahead of us in the next few days, and we'll keep you informed as to schedule as things can get scheduled.
Republican Leader is recognized. The Senate will be in order. Would senators please take their conversations to the cloakroom?
Madam President, we've set a very unfortunate precedent here. This means that the Senate can ignore, in effect, the House's impeachment. It doesn't make any difference whether our friends on the other side thought he should have been impeached or not. He was. And by doing what we just did, we have, in effect, ignored the directions of the House, which were to have a trial. We had no evidence, no procedure. This is a day that's not a proud day in the history of the Senate.
If you want to find her, that would be.
Madam President.
Senator from Utah is recognized.
Madam President, I ask unanimous consent to enter into a colloquy with my Republican colleagues.
Without objection, so ordered.
Madam President.
Senator from Utah would hold. We do not have order in the Senate. I would ask all senators to take their conversations to the cloakroom as well as the staff. The senator would just hold till we have order, please. Senator from Utah is recognized.
Thank you, Madam President. What we've witnessed today is truly historic. This has never occurred. Nothing like this has ever occurred. You know, under Article 1, Section 3, Clause 6, we've been given a duty. We've been given the sole exclusive power to try all impeachments. Try all impeachments, not some of them, not just those with which we have happened to agree, not just those that we are happy that the House of Representatives undertook to prosecute, but all. The word try is also significant. It refers to the word trial. It's the same word. It's a proceeding in which the law and the facts are presented to finders of fact in front of judges in order to reach an ultimate disposition. In a criminal proceeding, it would be an ultimate disposition culminating in a verdict of guilty or not guilty. We were precluded from doing that job today, and we were precluded from doing so in a way that is not only ahistoric and unprecedented, but also counter-constitutional. Nothing could be further from the plain structure, text, and history of the Constitution than that. So let's look at the arguments that we would have heard, that we could have heard, that we should have heard today, had things unfolded as they were supposed to. Had things unfolded in a manner consistent with the oath that we took, first when we were sworn in as United States Senators. We're all required to take the same oath to the Constitution when we did that, but also the oath that we took just a few hours ago in this very chamber, in this very case, to decide this case impartially. What would we have heard? Well, first and foremost, regardless of what you think about what a trial consists of or how different people might cleverly define the term, a trial will always, at a minimum, involve lawyers. And unless the person is proceeding pro se, you will always have lawyers there. Or at least one side will always be represented by lawyers, and in 99.9% of all cases, both sides will. You will hear from lawyers. We didn't hear that today. We didn't hear from the committee of individuals appointed by the House of Representatives to be the House impeachment managers or prosecutors. What else would you expect to hear? Well, you'd hear evidence. Evidence would be brought in. Sometimes trials in the Senate involve bringing in evidence in a documentary form. Other times you might have witnesses. We didn't have any witnesses. We didn't have any documentary evidence other than that which was charged. So let's talk about what was charged and what evidence we could have, would have, and should have heard had we done our job today. Well, the accusations in this impeachment trial can be fit into two categories. Category 1 is found in Article 1 of the Articles of Impeachment. Article 1 alleges that Secretary Mayorkas repeatedly, defiantly did the exact opposite of what federal law requires, namely that under myriad circumstances, 8 or 9 different statutory provisions that he violated, he was required to detain people whom he did not detain. But it's not just that he didn't do what the law required, he did the exact opposite of that. Instead of holding them until such time as they could be removed or alternatively adjudicated to have the status, whether under whether in the context of immigration parole or asylum or otherwise, he just released them. And in many cases, gave them work permits. We would have heard evidence about the fact that memoranda issued by Secretary Mayorkas within the Department of Homeland Security didn't just tolerate this result, they instructed this result. We would have heard evidence about the fact that at the outset of the Biden administration, Secretary Mayorkas, when asked what he would tell those traveling through the caravans, those paying many thousands of dollars per head, in some cases tens of thousands of dollars per head, to international drug cartels, instead of telling them don't do it, he said, maybe don't do it yet. Give us a few weeks before we're ready to receive you. Showing intention, a forethought, to facilitate the violation of federal law. We would have heard evidence about how he instructed his own department to violate those rules. We would have heard evidence about how directly contrary to federal law those things are and contrary to his own oath and his own duties. Now, as to Article 1, the Senate chose to dispose of this today by doing something it's never done in any context anywhere close to this, with a point of order that said as follows. The majority leader stood up, defiantly refusing to have the Senate perform its obligations, and raised the following point of order. He said, I raise a point of order that Impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution is therefore unconstitutional. All right, let's talk about that for a minute. Now, had we been permitted to have a trial, alternatively, had we been permitted to go into executive session, alternatively, had we been permitted to go into closed session, as several of us moved today, we would have been able to hear arguments about this, about how wrong this is, because that's what you do when you have a trial. You hear evidence, you hear arguments from lawyers, and when someone makes a legal argument, as Majority Leader Schumer just did, you can consider their implications, and most importantly, consider whether or not the argument is right. Because when we're sworn in a trial of impeachment, our job is to serve as both finders of fact and adjudicators of law relevant to this case. We were denied that opportunity. So while we're exploring what we would have heard had we gone to trial, had we done our job, let's also explore what would have happened in a real trial had somebody made an actual motion and we've been permitted to do our job. Well, look, first and foremost, this is patently absurd to argue that a willful refusal to obey the law that one has a sworn solemn obligation to perform is somehow not impeachable. We don't have to look too far in order to find support for the conclusion that this is an illegitimate, unwarranted, unsubstantiated claim, one that's directly contrary to law. In fact, we don't have to look further than President Biden's own lawyer, the Solicitor General of the United States, who holds a special position within our federal government, performs functions that many people mistakenly associate with the Attorney General. But it is, in fact, the Solicitor General who is the United States government's chief appellate advocate and chief advocate before all proceedings in the U.S. Supreme Court. There was an exchange in a case argued last term in the Supreme Court of the United States called United States versus Texas. In that case, the Supreme Court heard arguments from the state of Texas about whether or not this administration's approach toward these same provisions of law is acceptable, whether or not they could challenge them. Now, unfortunately, the Supreme Court reached a conclusion with which I strongly disagree, and the Supreme Court concluded ultimately that the state of Texas lacks standing to challenge federal policy along the lines of what we're discussing today, notwithstanding the fact that it's conduct that inflicts substantial harm on the state of Texas and its residents. But the important part that we should have been able to argue here today is the exchange that occurred at oral argument between Justice Kavanaugh and Elizabeth Prelogar, Solicitor General of the United States, in her capacity as Solicitor General, as the Biden administration's chief appellate advocate and chief advocate before the United States Supreme Court. Justice Kavanaugh asked her a number of questions at oral argument, and on page 50 of that argument transcript, some of that discussion ensues. He asks the following: if a new administration comes in and says we're not going to enforce environmental laws, we're not going to enforce labor laws, your position, I believe, is that no state and no individual and no business would have standing to challenge a decision to, as a blanket matter, not just not enforce those laws, correct? Here's what Solicitor General Prelogar says. Quote, that's correct under this court's precedent, but the framers intended political checks in that circumstance. You know, if an administration did something that extreme and said we're just not going to enforce the law at all, then the president would be held to account by the voters, and Congress has tools at its disposal as well. So this argument continues on to the next page, in which Justice Kavanaugh says what are the exact tools that Congress has to make sure that the laws are enforced. And Solicitor General Prelogar answers. She says, well, I think Congress obviously has the power of the purse, and she goes on to explain how this is relevant. And then this goes on until we get to page 53, and then at page 53, Justice Kavanaugh jumps back in and says, I think your position is, instead of judicial review, Congress has to resort to shutting down the government or impeachment or dramatic steps of some sort or another. Solicitor General Prelogar responds by saying, well, I think that if those dramatic steps would be warranted, it would be in the face of dramatic abdication of statutory responsibility by the executive. So she just acknowledged exactly what has happened here, and she acknowledged that is exactly the moment at which the impeachment power becomes very relevant. Lest there be any doubt on that, this stuff was settled not just in 1789, when we adopted the Constitution, and when the framers used the language that they did. But remember, the framers were not operating in a vacuum. They were not writing on a blank slate. They were incorporating legal terminology that had been in use for centuries. In fact, Justice Story, in his treatise on the Constitution, discusses this very kind of thing and explains in section 798 of his famed treatise, written not so very long after the Constitution itself was written, that we got this stuff from England, that the British knew what impeachment meant, and they understood what would constitute a high crime or misdemeanor. In section 798, Justice Story acknowledges that there was precedent, there was an understanding at the time of the founding that recognized that you would have an impeachable offense if, among other things, a Lord Admiral would have neglected the safeguard of the sea. They didn't have a Homeland Security Secretary then, not in America, not in Britain. But this is really analogous. This is the exact same thing. Somebody who had a duty to do a certain thing under the law defiantly refused to do so. Those are arguments we could have and would have and should have heard today had we had an actual trial, had we been permitted even to go into executive session, or even to go into closed session. Why closed session? We don't want to have to do it in closed session. But you see, the standing rules of impeachment in this body preclude us from having this very kind of debate. So when Majority Leader Schumer made this argument, to the great shock and surprise of all of us, we wanted to warn the body and have this debate. He wouldn't let us do that. The Democrats voted us down. So that's That's Article 1 in a nutshell. Article 2 of the Articles of Impeachment, what do those get to? Well, those are interesting because those deal with false statements, knowingly false statements repeatedly made by Secretary Alejandro Mayorkas to Congress. To Congress as it's performing its oversight responsibilities. He lied to Congress according to the allegations of the Articles of Impeachment in Article 2. To my great shock, look, he was dead wrong as to Article 1. But if he was dead wrong as to Article 1, he was deader than a doornail, whatever that means. 10 times more dead as a doornail as to Article 2 than he was to Article 1. Why is that? Well, because they allege in Article 2 that Secretary Mayorkas knowingly made false statements. Knowingly making false statements is a felony offense. It's punishable as a crime, as a felony federal offense under, among other things, 18 U.S.C. Section 1001. It's routinely charged, prosecuted, and is the basis for lots of convictions for a felony offense. You can go to prison for a very long period of time for that. Now, for Chuck Schumer to argue...
Senator Yield.
Yes.
I just want to be able to be sure I understand, Senator. I thought I heard...
Microphone.
Madam President, I asked Senator Lee if he would yield to a question. I thought I heard Senator Schumer argue today that lying to the United States Congress was not a high crime or misdemeanor, and therefore could not be the basis for an article of impeachment. Did I hear that correctly?
That is exactly what he said. That is exactly what he said when he made this motion, because he stood up and he said, I raise a point of order that impeachment Article 2 does not allege conduct that rises to the level of a high crime or misdemeanor.
So, even though lying to the United States Congress is a felony, under the precedent that the majority leader and our Democratic colleagues established, it's not a high crime or misdemeanor? Is that what we did?
That is precisely what the precedent established today stands for. That is, we've effectively, by this vote that the Democrats forced through, not even allowing us to debate this, and this is why I raised a point of order or this is why I made a motion that we go into closed session to discuss this, because we've now set a precedent that effectively, very arguably effectively immunizes from impeachment, making a false statement to Congress.
May I ask one more,
yes.
Senator?
Yes, please.
Well, I'm trying to follow the Senate Majority Leader's logic. What do you have to do to get impeached now? I mean, a felony is not sufficient. What's above a felony?
Well, let's see. Obviously, spreading what they deem misinformation on the internet might be a felony. I suppose at some point...
But it takes, as I understand it, Senator, you're a legal scholar, it takes more than a felony now.
A high crime or misdemeanor.
Yeah,
it takes more than a high crime or misdemeanor.
What's on second? I don't understand any of this, and I'm very, very worried and would like your thoughts or others' thoughts about the precedent that our Democratic colleagues, in their haste to sweep this under the rug, may have established.
Yep.
Will the gentleman from Louisiana yield for an adjunct question
With
to
pleasure.
his question?
With pleasure.
So the law says that lying to Congress is a felony. Since we're no longer using impeachment as a means to address someone who's lying to Congress, how does Congress prosecute or address someone who deliberately lies to Congress now that the Senate has swept away through this presidential action today the opportunity to use impeachment for that purpose? Thank you.
Yeah, and I'd love to respond to that point briefly, if I could. What we've done is to effectively immunize this against impeachability. Immunize making false statements. And going back to the original question, I don't know, maybe aggravated first-degree murder with heinous, atrocious, and cruel conduct as aggravators. Maybe that's still a high crime or misdemeanor. That remains to be seen. But keep in mind, particularly with the fact that they already set aside Article 1, and they've already said that that's out of bounds as well for impeachability. The Supreme Court has said pretty much nobody has standing to address that. What are we left with? And getting back to the question from Senator Lummis, this is a phenomenally dangerous precedent to have set here, specifically with regard to the false statements. Because what does that do to our oversight hearings, where we rely routinely on testimony provided under oath by cabinet secretaries and other administration officials? What does that do? What incentive structure does that create? What perverse incentives does that create for them to lie?
With this, Senator Gill?
Yes.
Are you aware, here's a question, are you aware of the fact that President Clinton was impeached? And one of the charges against him was lying under oath in a civil lawsuit. Are you aware of that?
Yes.
Okay, so you can be impeached for lying under oath in a civil lawsuit, but apparently you can't be impeached for lying to Congress about how you do your job. So here's what I'll give Senator Schumer the benefit of the doubt, Senator Kennedy. He's saying that the fact pattern here apparently doesn't rise to the level of high crime or misdemeanor, that we don't have a situation, it's a policy disagreement. We've taken a policy disagreement in the House and tried to turn it into impeachment. Well, here's a question for you, Senator Lee. Are you aware of the fact that 2 days ago, Secretary Mayorkas was asked about the parole of the man alleged to have killed Laken Riley, Mr. Ibarra? Why was he paroled and how he was paroled? Under the parole statute, 212D5, there's 2 ways parole can be granted. Unique humanitarian need, circumstance. Your mother's dying. Something's going on bad. You need to get into the country on a temporary basis, or special benefit to the United States. That means you're a witness in a probably cartel trial. Those are the only 2 reasons you can be paroled. And 2 days ago, no, yesterday, Secretary Mayorkas said he did not know why Mr. Ibarra was paroled. Which one of the 2 was it? This was a question from Congressman Bishop. He said, I didn't know. At the same time he said, I didn't know, I had the file, and it says, subject was paroled due to detention capacity at the Central Processing Center in El Paso, Texas. In the file, he was paroled because they didn't have any space for him. Senator Schumer, this is illegal. The Secretary of Homeland Security cannot just add a condition to a statute. The statute doesn't allow you to give parole because you're full. And the reason this man was given parole is not because of the statutory requirements, because we'd run out of space, because we got more illegal immigrants than we can handle, and the rest is history. He gets paroled, he goes to New York, he gets convicted of a crime, he goes to Georgia, and he's accused of murdering this lady. Seems to me that would be something we should argue over as to whether or not you should lose your job. Because you got a statutory requirement limiting your authority to parole people, and in your own file, Exhibit A, you paroled him because the place was full. This happened 2 days ago. So this gives kangaroo courts a bad name. This is a friggin' joke. We have a nation under siege. 1.9 million people have been paroled. Are you telling me they do an individual analysis on all the people? In November 2023, I asked him, Secretary Mayorkas, Do you do a case-by-case analysis? Senator, we comply with the law. So you're telling me of all the 240,000, the ones in front of us, you determine they meet the criteria of urgent humanitarian need or significant public benefit? And he said yes. This was in November, under oath to me, when I questioned, I don't believe you. I don't believe you're doing an individual analysis on this stuff. You're doing blanket parole and you're paper whipping this stuff. It turns out he gave false testimony to the Congress. Whether he lied or he's just doesn't know what he's doing, I don't know. You should be impeached either way. If you don't know what you're doing, you should be kicked out because you don't know what you're doing. But the man that we're talking about is the one charged with murdering this young lady who was going on a jog. If that's not important to the American people to find out how that happened, and should somebody be held responsible, what the hell is? You can talk about why we impeached Trump and Clinton. Was it worthwhile? Did it matter? Was it all political? You cannot say this is not important. To say that how he's doing his job is not important to the American people. Tell that to the Riley family. This is not an academic debate. The policies of this administration being carried out by Secretary Mayorkas are illegal. The man charged with killing Laken Riley was illegally released into this country by DHS. That should be something we argue about in the Senate as to whether or not you keep your job. It's been swept under the rug. There will be an election in November. This is the only chance you have to get this right to the American people. We had a chance today to hold somebody accountable, finally, for all the rape and the murder and the drugs. The largest loss of life in America is fentanyl coming through the border for young people. How many more people have to be die, raped, or murdered before somebody is held accountable? We had a chance here, and our Democratic friends swept it under the rug because they're more concerned about the November election than protecting the American people. And this is a sad day for the Senate.
Law-trained kangaroos everywhere
are
going to be offended by the use of the term kangaroo court. In fact, the entire marsupial world will be offended by this. Senator Marshall, you have a question?
Yield.
Yes.
It certainly seems to me that today 51 of our friends across the aisle voted to not have a trial. Make note of this, that every person voted in that trial was a vote for an open border. It was a vote to tell Laken Riley's family that the life of their daughter didn't matter. It was a vote to tell the 250,000 families that lost a loved one to fentanyl it doesn't matter. But what struck me as the clock struck midnight here and we lost that vote, I feel like the Senate was gutted, that we lost part of our powers. You know, in high school high school government, we were taught about checks and balances. And one of the checks and balances that the legislative branch had on the executive branch was this impeachment process. And I want to ask my colleague from Texas, why do I feel like I've just been gutted right now, like the entire Senate, that this body has been gutted of a power that we're never going to get back, that impeachment going forward may mean nothing? Am I wrong?
I'm sorry to say that my friend from Kansas is not wrong. In the 237 years of our nation's history, I don't know that there has been a more shameful day in the United States Senate than today. What we just witnessed was a travesty. It was a travesty to the United States Constitution, and it was a travesty to the American people. And it's important to understand why the Democrats did what they did. We're here on the Senate floor right now, but I want the record to reflect I'm going to do a very accurate count of the number of Democrats who are with us. That would be 0, other than the presiding officer, and somebody has to preside. Not a single Democrat senator chose to come to this floor and listen to one word of evidence. when it comes to the Constitution. The Democrats concluded that Joe Biden and Alejandro Mayorkas, defying federal law, ignoring the text of the statute, deliberately releasing criminal illegal aliens over and over and over again, that's just hunky-dory. You can't impeach him for that. Every Democrat just voted. By the way, every cabinet member, guess what? You've just been given a blank slate. Ignore the law. When Democrats are in charge of the Senate, the entire cabinet could ignore the law. It is no longer impeachable. In Democrat Wonderland, when a member of the executive branch openly defies the law. By the way, every Democrat just voted that way. They didn't hear one word of argument. The majority leader didn't stand up and say, here's the reason why it's okay. No, he didn't present that argument. They didn't read a brief. Nobody wrote a brief. They didn't care enough to know what Senator Lee just laid out, that the Biden Department of Justice went in front of the U.S. Supreme Court and said if the executive defies the law, the answer is impeachment. The willingness of every Democrat to be blatantly hypocritical. Just last year, the Biden Justice Department said, no, you can't sue in court when we, the Biden administration, defy the law. The answer is impeachment. In like three-card money. Every Senate Democrat said, no, the answer is not impeachment. I don't know what it is. Actually, I do know what it is. There's only one answer left, which is everyone who is unhappy about the open border shows up in November, and to use the phrase, throw the bums out. Because if you're not willing to do your job, is there not one senator on that side of the aisle who cares enough to honor the Constitution? By the way, the second article they threw out said lying to Congress is not a high crime or misdemeanor, it's not impeachable. Now, as the senator from South Carolina pointed out, Bill Clinton was impeached for lying under oath. And you know what happened? And he was ultimately acquitted. But after a full trial where they heard the evidence, where the Senate did its job. By the way, one of the impeachment managers was Senator Graham, who presented that evidence right here on this floor. And you know what? Before Bill Clinton, there's a guy named Walter Nixon. You may not know who Walter Nixon is. Walter Nixon was a federal judge who was convicted of perjury. He was from Mississippi. He was convicted of perjury in front of a grand jury. And he was impeached. And it went to the Senate, and the Senate convicted him and removed him from the bench. So you want to know what the precedents were prior to today? You commit a crime, lying under oath, perjury, it is a high crime or misdemeanor that is impeachable. No more. Because understand the Democrats' rule here. This is not about the Constitution. None of them care. By the way, we repeatedly moved. Let's go into debate. Hear the other side of the argument. Nope. Look, the famous three monkeys, hear no evil, see no evil, speak no evil. That's just evil, what they did. They don't want to know because they don't care, because it's not about the Constitution. It's not about the law. It is about political expediency. But every bit as violent as what they did to the Constitution was, it's even more offensive what they did to the American people. Last year, 853 migrants died crossing illegally into this country. That's almost 3 a day. You go down to the southern border, you go down to Texas, which the Democrats don't bother to do because they don't care about the people dying. And you see photograph after photograph that Texas farmers and ranchers are finding of dead bodies on their property. Many of my colleagues here have been down there with me, have seen the elderly people the human traffickers have abandoned, have seen the pregnant women the human traffickers have abandoned, have seen the infants and toddlers left to die. The Senate Democrats just told the American people they don't give a damn about the bodies and the people who have died the last 3.5 years, and they don't give a damn about the people that are going to die next week. Next week, more migrants are going to die. When we brought 19 senators down to the border, we went out on a boat in the Rio Grande. We saw a man floating dead in the water. Senator Lee was there. Senator Kennedy was there. He had died that day. The Democrats just told the American people they don't care. When you go down to the border and you look at the children who've been brutalized, just about all of us here are parents. I will tell you, when you look in the eyes of a little girl or a little boy who's been abused by traffickers, and you see it, you see the pain, you see the agony of children trapped in sex trafficking, the Democrats just said they don't care. They won't hear the evidence, they don't care that it's deliberate, and they don't care that it'll happen next week, that it'll happen tomorrow. Tomorrow there will be children brutalized because of the Democrats' open border policies, and not a one of them cares. They don't care about the women who are repeatedly sexually assaulted. Again, when you look in the eyes of these women coming over, it's heartbreaking. And the Democrats just said, we don't care. And they don't care about the more than 100,000 Americans that died last year from drug overdoses. The highest in our nation's history. 70% of that is from Chinese fentanyl coming across our southern border. And the Democrats said, we don't want to hear about it. We're not interested in the Americans dying. You know what they also don't care about? They don't care about the criminals that are being released day after day after day. The Biden administration is releasing murderers and rapists and child molesters, and every week we see another story of somebody being killed, somebody being raped, another child being assaulted by illegal immigrants released by Alejandro Mayorkas and Joe Biden. How shocking is it that there wasn't one Democrat who says, you know, massive human suffering matters? We ought to hear the evidence. How shocking is it that there wasn't one Democrat? One! There are 51 of them on that side. Not a single one could screw up the courage to say, let's do our job, let's hear the evidence. How shocking is it that not a Democrat cares about the terrorists who are streaming across our southern border? The nation of Iran has called for jihad against America. Hamas has called for jihad against America. Hezbollah has called for jihad against America. And Joe Biden and the Democrats have put out a red carpet and said, if you want to murder Americans, come across our southern border, and we, the Democrats, will welcome you. Like many of us on this floor, I was in Washington, D.C. on September 11th, 2001. I remember the horror. I lost a good friend, Barbara Olson, who was in the plane that crashed into the Pentagon. I remember the smell of smoke and sulfur and burning. I remember the agony, and I remember the national unity that came after 9/11. As Democrats and Republicans came together, I don't know that I've ever been more proud of a president than when President George W. Bush stood on a pile of rubble with a bullhorn, talking to firefighters and New Yorkers, and one of the men in the crowd called out and said, "We can't hear you," and he responded, "Well, I can hear you, and soon the whole world is going to hear you as well." We were as one. Today, not a single Democrat was able to mount up the courage to tell the majority leader, you know what, I don't want another 9/11 to happen. The House impeached Alejandro Mayorkas for, among other things, releasing terrorist after terrorist after terrorist. We ought to hear the evidence. I believe today we have a greater risk of a major terrorist attack on U.S. soil than at any point since September 11th. And every Democrat just told the American people it doesn't matter to them to hear the evidence. I appreciate my Republican colleagues who are here, who are willing to hear the evidence, willing to engage, willing to stand up and defend the American people. But you know what? The Democrats who aren't here, they aren't here because you know who's also not here? If you look up at the gallery, the reporters are all gone. A couple of folks in the back, I hope you're all right. But the reporters are absent. That's the Democrats' plan. What is fascinating, we're presenting arguments. Many of us, particularly those of us in judiciary, but many of us have presented those arguments over and over and over again in hearings. Not a Democrat argues on the other side. It's an issue unlike any other issue I know of in politics. Listen, if we're arguing about taxes, as Republicans, we say we should cut taxes. It's good for the American people. And you know what Democrats do? They stand up. We know their talking points. No, tax the rich. Okay, fine, we have a debate. We're talking about just about every issue. The Democrats will argue on the other side. They have their spin. What is fascinating? Where's Dick Durbin, chairman of the Judiciary Committee, standing up saying, no, it's not right that migrants are dying every day. No, it's not right that children are being assaulted every day. No, it's not right that women are being sexually assaulted every day. No, it's not right that they're releasing terrorists every day. They're not there. Not a Democrat is there. Why? Because you cannot defend it. I'll tell you, South Texas for 100+ years has been a Democrat region of our state. It is turning red with the speed of a freight locomotive because nobody can see the suffering that is unfolding and defend it. And the Democrats, by their silence and by the complicity of the press corps, they are counting on the press corps to write story. Victory for the Democrats, yay! They got rid of the impeachment trial. That's the headline they want. Understand they don't have a substantive defense. None of them disputes a word we are saying. Not a single Democrat has stood up and said, it's wrong that Laken Riley would still be alive if Joe Biden hadn't let her murderer go. They know it's right. The reason they didn't want a trial is they don't want the American people to hear about it. And it's our obligation to make sure the American people do.
Senator Ricketts is the former governor of Nebraska. I'd love to get your perspective on this.
Thank you very much. Appreciate the colleague from Utah organizing this. My. What have our majority leader and the Democrats in the Senate wrought? They have overturned 227 years of precedents that my colleagues have talked about. 21 previous impeachments, all scheduled for trial. 17 came to trial, and the ones that did not because the person who was to be impeached was either expelled or dismissed prior to the trial. To my colleague from Texas's point about the media being complicit, one of the headlines in Politico that I was told about said the trial lasted only 3 hours. There was no trial. There was no trial. The majority leader decided that he could determine what was unconstitutional and get every single one of his Democrats along partisan lines to vote for it. Said it was unconstitutional. Did not rise to the level of high crimes and misdemeanors. Let me briefly examine that. Article 1, sent over to us by the House. I'm just going to read the title. Willful and systematic refusal to comply with the law. That's Article 1. Let me tell you about complying with the law. Prior to this administration, the Trump administration had brought illegal crossings down to a 45-year low. What we have seen since then is an explosion of illegal crossings. Over 1.7 in the first year of the Biden administration, nearly 2.4 in the second, nearly 2.5 in the third. Now, if you count all the people who've tried to cross the border illegal or have crossed the border, including the gotaways, it's 9.4 million people, larger than the population of New York City. 300,000 in just December alone. That is larger than our capital city, Nebraska, Lincoln. The evidence is right there that we're not doing a good job at the southern border. And why would that be? Well, because Alejandro Mayorkas is complicit in not following the law. In a memorandum Mayorkas sent to Immigration and Customs Enforcement officials in 2021, he said, and I'm going to quote here, the fact an individual is a removable non-citizen, notice he doesn't even say illegal alien, which is what it says in the law. He says the fact that an individual is a removable non-citizen therefore should not alone be the basis for an enforcement action against them. Basically saying just because you broke the law doesn't mean we have to enforce the law. That right there should tell you he is willfully disregarding the law. Absolutely. Or how about the case of parole, where the law says that it's only supposed to be used on a case-by-case basis in situations where the person has an extreme humanitarian need or it's in the best interest of our country. Under the Obama and the Trump administrations, it was used an average of 5,600 times, paroled 5,600 foreigners in this country between the Obama and Trump administrations on an annual basis. Last year alone, Mayorkas paroled into this country 1.2 million for whole classes of people. A clear abuse of the law. Folks, when you see instances where the Secretary for Homeland Security is not following the law, doesn't that raise the question, shouldn't we have a trial? Shouldn't we examine whether or not he actually should be convicted of this? And yet, as my colleagues have pointed out, not a single Democrat, partisan line, said no, that is not willful disregard of the law. Let's move on to Article 2. Article 2, again, I'm just going to read the title of this. Sent over, says breach of public trust. Breach of public trust. Well, what does that mean? How about misleading Congress? Wouldn't that be a breach of public trust? On April 28, 2022, Mayorkas testified repeatedly in front of the House Judiciary Committee that DHS possessed the operational control of the southwest border, including in accordance with statutory definition. But I just told you how the number of people crossing the border had exploded. My colleague from Texas did a great job of talking about the human suffering this created. If we had been allowed to have a trial, we would have heard from Border Patrol agents who would have come up and testified personally that the border was not secure. I have been down to that border as well, 4 times. I've seen the people coming across. That border is not secure. In the last trip down there, it was mostly Hondurans, but it was a couple from Moldova on the Russian border that had paid to get across to our border because the whole world knows it's open. This is absolutely what we are talking about. That this is why we have to hear the evidence to go and determine whether or not there is guilt or innocence, and the Democrats have denied it, and it is to the detriment of our Constitution and our country that we are not being allowed to have a trial, to examine the evidence, and determine whether or not Alejandro Mayorkas is guilty and whether or not he should be impeached. I think the few things I have laid out here this afternoon go exactly to we should examine the questions. And the Democrats chose not to even ask the questions before they dismissed us entirely. Thank you to my colleague from Utah for giving me the opportunity to be able to address these issues.
Thank you. Before he had his name changed legally for purposes of this chamber to the junior senator from Missouri, Attorney General Eric Schmidt was one of the nation's leading legal minds engaged in this problem, engaged in trying to address the lawlessness at our southern border brought on by the policies of this administration. I'd love to hear his perspective on what happened today.
Thank you, Senator. Yeah, I take this in 2 parts. I think it is important for us to actually digest, for the folks here watching or in the gallery or the press folks who are here who've left, to really understand what happened today. Because what happened today wasn't some disagreement about the number of amendments we might have on an appropriation bill or whether or not some vehicle is going to be a priority or not. What was established today was a new precedent, something that had never taken place in this chamber in the history of our republic. What the Senate Democrats decided to do with a simple majority was to bulldoze 200 years of precedent that said something very simple, that this chamber would honor our constitutional obligation and conduct a trial, to hear the evidence. There's no real debate. We were to hear the evidence from witnesses, counsel is present. There's a whole process, there's a whole procedure that's been established, finally wrought throughout the ages, that we were to honor. When we raise our right hand, when we get sworn in, to honor. When we got sworn in today, to honor as United States senators. That's all gone now. Maybe forever. I don't see a circumstance now. You heard the parliamentary inquiries asking if a precedent had ever been established for this or that. 100 years from now, when somebody else has Harry Truman's desk, if I remember to carve my name in it before I die, we'll have this desk. I don't know that person's name. I don't know their background or what their life experience will be. But they'll know what happened today. They'll know that the United States Senate under Chuck Schumer, who will go down as one of the worst U.S. senators in American history because of his actions today, will know that we just blew off an important duty to conduct a trial. It wasn't, an idea, and to paraphrase my friend from Louisiana, it wasn't some, gamer bro with a tweet. These were articles of impeachment voted on by the people's representatives in the House of Representatives, walked over here and delivered. And so Chuck Schumer and the Democrats who voted for that, they're going to have to own that. And to paraphrase something the senator from Kentucky said just a few years ago, I think they're going to regret it. And I think they're going to regret it sooner than they think. So having said that, what was this trial supposed to be about? And as the senator from Utah mentioned, when I was Attorney General in Missouri, we brought the first lawsuit against the Biden administration for their actions at the southern border, when they decided to undo remain in Mexico. We were successful for a while. But what came out of that was a lot of what you might have read in Article 1 of the impeachment that were brought over. A lot of those were from, arguments were from that case. And as an interesting little side note, when we won, when we had an injunction in place actually for the Biden administration to keep this very important protection in place, they ignored it. We had to go back in front of a judge time and time again to get them to abide by the law. But what we have found out from this administration, and Secretary Mayorkas specifically, is he himself is willing to subvert the law, to believe that he is above the law, to lie and to commit a felony that this chamber now has said doesn't rise to the level of a high crime and misdemeanor forever. That is the precedent forever. So the human toll of this lawlessness at the border that has been overseen by Secretary Mayorkas is devastating. Thousands of people die every month for fentanyl abuses or overdoses. We have a ticking time bomb in this country with the national security threat. We don't know who 2 million people are. 9 million people have come here illegally. Most of them have been told, please show up for a court date sometime in the 2030s. That's not going to happen. But 2 million of them, we don't know who they are, we don't know where they're from, we don't know where they're at. We're seeing a record number of Chinese nationals come across just in California alone. People from all across the world coming here